Hi, everybody. We are starting our presentation tonight, Montana Lawyers and Libraries. This is Missoula Public Library, and we're presenting this on behalf of the Montana State Library. And we've got a couple of presenters here this evening, Robin Turner and Lillian Alvernaz. And so without further ado, those ladies are gonna go ahead and take it away.
Thanks, Sarah. Hamitakiapi, Ishkiawanchiakapi, Moshitria, Lillian Alvernaz, Imakiapie. Hello, my relatives. My name is Lillian Alvernaz. My pronouns are she, her, hers. I'm Dakota and Nakota. I'm the Indigenous Justice Legal Fellow for the ACLU of Montana, and I am so grateful that each of you are here with us this evening. And I'm also pleased to hand it over to my co-presenter, Robin Turner.
Thanks, Lillian. Hi, everyone. My name is Robin Turner. My pronouns are she, her, hers, and I am an attorney at Reese Law Group, which is a law firm in Missoula that specializes in civil legal services to survivors of domestic violence, sexual assault, and stalking. Prior to my time at this law firm, I spent a great deal of time with the Montana Coalition Against Domestic and Sexual Violence, where I worked on policy issues as well as provided services to survivors. We're really excited to be here today to present Law Day 2020. So the purpose of Law Day, what Lillian and I are here to do is to talk a little bit about this national event that is held by libraries all across the country. And this is no exception here in Missoula. Basically, the purpose of Law Day is to examine the role of law in our society and to speak about a deeper understanding of our legal profession. When Law Day was proposed, they asked for volunteers, and Lillian and I volunteered to present in Missoula. The initial theme of Law Day was about the 100th anniversary of the 19th Amendment, as well as access to justice and legal resources for Montanans. As we were thinking about the purpose of Law Day, we thought it was important, while we speak about the 19th Amendment and we speak about its 100th anniversary, that we also talk about the development of voting rights in the United States and how sometimes these movements have left out certain members of our community. And so we want to talk about the progression of voting rights in the United States and the work that is still left to be done today. And so we're both really excited to speak a little bit more on that for you all tonight. The 19th Amendment of the United States Constitution reads, the rights of citizens in the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Congress shall have the power to enforce this article by appropriate legislation. So this constitutional amendment has been ratified, and there is a long history to the 19th Amendment and how we ended up with this amendment to the Constitution. There's certainly not enough time to talk about all of it, and frankly, I want to get to the really good stuff, which is the voting rights work that Lillian is doing at the ACLU of Montana. But I want to talk a little bit through some of the highlights on our way to passage of the 19th Amendment. So how did we get here? Women's leadership and participation in voting wasn't new in some communities. Feminists in the colonized state of New York, for example, were inspired by women in Native American communities, including traditional Iroquois, who had the authority to vote for centuries before Europeans came to the United States. These women ignited a revolutionary vision for early Euro-American feminists by already providing a model of freedom and agency. Additionally, prior to the Revolutionary War, women had voted in some conditions in the United States colonies. However, generally, women lost the right to vote in all state constitutions after the Revolutionary War. Women and African American men lost that right. To jump ahead a little bit to Montana, women were not granted the right to vote in the formation of even our first constitution. So suffragists in the 19th century maintained that they were not asking for a new right, but that they wanted to retain the right that their foremothers had possessed. This may not be new to anyone sitting here, but in many states, married women couldn't own property, and they had no legal claim to the money they might earn. Women were expected to focus on housework and motherhood, not politics, or I suppose not both. So women had developed their organizational skills long before a formal suffrage movement began. There were female anti-slavery societies in the early 1800s, and organizing happened there. However, the first convention held in the country to exclusively discuss women's rights to vote was the Seneca Falls Constitution in June of 1948. And this was a 2-day conversation with a convention that resulted in the adoption of the Declaration of Rights of Women, the Declaration of Sentiments, and an accompanying list of resolutions. Interestingly, one of the most contentious resolutions was women's right to vote. So I'm going to be skipping a lot of statewide work and community-based organizing to get to the fact that after the Civil War in 1865, Congress passed the 13th Amendment, which outlawed slavery. In 1868, Congress passed the 14th Amendment, which granted citizenship to all persons born or naturalized in the United States and guaranteed equal protection of laws. And this did not apply to all people, as Lillian will talk about later. And then the 15th Amendment was passed in 1870, which guaranteed Black men the right to vote. So these were called the Civil War Amendments. But after the Civil War, the abolition and women's rights movements had worked together and were in a combined organization known as the Equal Rights Association. But after the Civil War Amendments were passed, these groups started to become divided over whether to support advances for African American men at the expense of all women. And so this split into 2 main organizations. First, the National Women's Suffrage Association and the American Women's Suffrage Association. So this was a difference in approach and philosophy. The National Women's Suffrage Association opposed the 15th Amendment, which provided Black men the right to vote unless women were included. On the other hand, the AWSA championed the 15th Amendment. This became increasingly the most single issue of the movement, which was really interesting because at the Seneca Falls Convention, it hadn't even been the most important issue discussed. And unfortunately, there was often an overt or covert racist pandering to Southern states and xenophobia and anti-immigrant sentiments. State suffrage organizations got to branch off and were allowed to segregate and work for the right to vote for white women only, and some advocates thought they had to choose. So backing up a little bit, at the 1851 Women's Rights Convention in Akron, Ohio, Sojourner Truth, a former slave, delivered what is now recognized as one of the most famous abolitionist and women's rights speeches. It's now commonly understood as the Ain't I a Woman speech in American history books. In some, though, her speech was about how women could change the world, and Truth's Blackness and her identity as a Black woman did not make her not a woman. That's the kind of intersectionality that she was having to navigate, which was, am I pushing for the rights of Black women and men to vote, or am I pushing for the rights of women to vote? And she didn't want to have to take a side. So this is all happening, and the split in the movement is happening, and I think it's a really important thing to think about as we talk about the progress of voting rights in the rest of our country's history. One important case I think that came out was the Minor v. Happerstat case. That was a case in which a woman in Missouri named Virginia Minor appealed the decision of the Missouri State, Secretary of State, the person who runs voting, and said that under the 14th Amendment, voting rights should extend to all people, and voting rights were an express right to citizenship. This case was appealed all the way to the U.S. Supreme Court, and the U.S. Supreme Court explicitly said, no, Virginia, we don't believe that citizens with them have an inherent right to vote. That isn't an inherent right of citizenship under the 14th Amendment. So unfortunately, an appeal through the Supreme Court was not successful to allow women the right to vote. So I want to speed along a little bit to some of the high points around the passage of the 19th Amendment. Basically in 1919, the suffrage movement, with the support of men who were in support of suffrage, again, women and different coalitions looking towards the right to vote, were able to succeed in passing a constitutional amendment with the House of Representatives in 1919. The Senate then approved that proposed amendment to the US Constitution, and then it was sent out to the states to be ratified. So in the United States, a certain percentage of states need to ratify a constitutional amendment for it to go into effect. It took a little over a year, but in August of 1920, the sufficient number of states approved and ratified the 19th Amendment, and it became a part of our Constitution. Tennessee was the last state that kind of tipped the 19th Amendment over the edge, but what I think is really interesting is there were 12 states that didn't pass the 19th Amendment prior, back in 1919, 1920, and Mississippi was the last state to do it, and they didn't pass the 19th Amendment until March 22nd, 1984. I just think that's interesting. So the timeline of the suffrage movement in Montana, actually in the Montana Constitutional Convention, again, the right for white women essentially to vote was proposed in the Constitutional Convention, but it wasn't included. Women could vote in school board elections prior to the passage of the 19th Amendment, so women could vote in local Montana school board elections. Montana men, when it came up as a state vote, they did support the right of non-Native American women to vote in 1914. As we all know, Jeanette Rankin was elected as the first female US Congresswoman in 1916 on the Republican ticket. You can see kind of a neat little ad there on the screen. And Montana itself, after Congress had approved the 19th Amendment, Montana ratified on August 2nd, 1919. So that's just a little summary of the progress that we made through the 19th Amendment. And now I want to talk a little bit more about the split between the abolitionists and the suffragists and how it kind of extends to today. So after the 15th and 19th Amendment, many voters still face ballot restrictions, including registration rules, literacy tests, poll taxes, and moral and residency requirements. And that is not a thing of the past, as you will hear soon, and if anyone's paying attention to voting lawsuits in the country, you know that as well. So when we think about the 19th Amendment, I certainly understand why people are celebrating its 100th anniversary. As a woman myself, of course, I appreciate that. But how do we reconcile a suffrage movement with a movement for equality of people of color? We have to evaluate the ways that white women's progress in 1920 toward equality also negatively impacted equity for other people who were not white women. And so how do we do that? I think there are a lot of ways we can have this conversation, but one concept that Lillian and I were talking about as we were planning this is the concept of intersectionality. Lillian is going to pull up a video here, thank you, which explains intersectionality in the context of school.
Intersectionality is just a metaphor for understanding the ways that multiple forms of inequality or disadvantage sometimes compound themselves, and they create obstacles that often are not understood within conventional ways of thinking about anti-racism or feminism or whatever social justice advocacy structures we have. Intersectionality isn't so much a grand theory, it's a prism for understanding certain kinds of problems. African American girls are 6 times more likely to be suspended than white girls. That's probably a race and a gender problem. It's not just a race problem, it's not just a gender problem. So I encourage people to think about how the convergence of race stereotypes or gender stereotypes might actually play out in the classroom, between teachers and students, between students and other students, between students and administrators, and commit themselves to understanding that as a way of intervening and providing equal educational opportunity for all students, regardless of their identities. Identity isn't simply a self-contained unit. It is a relationship between people in history, people in communities, people in institutions. So schools do a good job when they understand that and when they commit themselves to curricular development, to opportunities in the school for all students to understand the histories that have brought us to this particular moment. You can't change outcomes without understanding how they've come about. So independent schools can take the lead on that to be responsive to their student populations and to the communities out of which the students come.
So again, this was a this intersectionality, if you saw the film, was a theory coined by Professor Kimberly Crenshaw, who you saw in that video. And it explains how race, gender, class, and other characteristics intersect with one another to create a unique experience, sometimes oppression and or advantages for different individuals. And so the conversation that we're having around intersectionality is, of course, how different people would have experienced this challenge of the right to vote. While white women might have experienced hardship because they weren't voting, they also were at least recognized as someone who was able to assert a right to vote, and that was not the same for all people. So I think it's possible in some, it's possible to celebrate the accomplishments of the women's suffrage movement and the 19th Amendment, but to also recognize that for some communities, the struggle for voting rights continued and came much later. And we have some really exciting developments even now. So with that, I will hand it over to Lillian Alvernaz to provide her presentation.
Thanks, Robin. That was great. I often get so focused in Indigenous history and Indian law that I often overlook a lot of the other history and timeline. So that was really informative. Thank you for that. As we stated earlier, my name is Lillian. I'm the Indigenous Justice Legal Fellow for the ACLU of Montana. So it's my primary job with the ACLU to focus on our Indigenous justice litigation. So all I do are our cases that affect Indian people or have to do with Indian law. I've been able to do things like write on what are called amicus briefs, friends of the support briefs, to the Supreme Court on a recent case that went up from Montana, which was really exciting. We've been working on free speech rights of Indigenous protesters against the Keystone XL pipeline. And something I'm very excited about is a case that I will discuss toward the end of my portion of the presentation, is a case fighting for voting rights of Indigenous people living on rural reservations in Montana, which I am so honored to do. So it's interesting that the people Indigenous to what is now the United States had to wait the longest to be able to participate in a foundational aspect of democracy. Keep in mind that these people performed our own self-government long before the founding of America. And it's also interesting or ironic that a lot of the first 100 years or so of federal Indian policy had to do with assimilating Native Americans or making Indian people look and act more like non-Indian settlers of the time. However, that assimilation did not come with the power of the vote. Our rights weren't fully recognized until very recently. In the 1866 Civil Rights Act, American Indians were explicitly excluded from that. We were seen as uncivilized and inferior. On that point, one case I like to bring light to is United States Standing Bear versus Crook, which established that Native American people are human beings and gave us civil liberties. They established that an Indian is a person within the meaning of the United States and thus entitled to civil liberties. I think that's especially important in my position at the ACLU, who is the primary watchdog of defending civil liberties. In 1884, Elk versus Wilkins, the United States Supreme Court explicitly denied the vote for American Indians, including those that did pay taxes at the time. And ultimately, Wilkins held that the 14th Amendment did not provide citizenship to Native Americans, but only by birth and citizenship, and Native Americans could only gain citizenship by an act of Congress. The next act is what some experts in Indian law and some regular Native people say is the most detrimental law to happen to Native people. The 1887 Dawes Act allotted our reservations and gave the head of household 80 to 120 acres. And keep in mind that the government viewed the head of household as often the male figure of the family, which goes against some tribes' matriarchal understanding of people, which one of my tribes is a matriarchal tribe, so that would have flipped our gender roles at the time on its head. What they did with the extra land, the surplus land, is they sold it to white settlers. So a lot of non-Indian encroachment on Indian land happened during this act. And even today, you'll look at a reservation and you'll see it's checkerboarded with Indian and non-Indian ownership. And that's because of this Dawes Act. A lot of non-Indian settlement on reservation land and a lot of non-Indian land ownership within the exterior boundaries of the reservation. So it is certainly one of the most devastating acts against Native people. Over 3 decades later, after federal Indian policies that included the treaty era, more assimilation era, and the relocation era, the federal government passed the Snyder Act, which is also known as the Indian Citizenship Act. Its anniversary is coming up on June 2nd. This act was passed in 1924. This act was another attempt to fully assimilate Indian people into non-Indian society, but still did not provide the right to vote. The United States Constitution gives states the rights to regulate their own elections. So even after Indians were granted citizenship, a lot of states passed laws that continued to make it impossible for Native people to vote. It wasn't until 1948 for the right of Native American people to participate in elections in the United States. However, several states continued to enact disenfranchising laws to make sure Native people did not obtain the right to vote. In fact, Native people were not able to vote in every state until 1962. In 1965, the Voting Rights Act was passed. Some say the Voting Rights Act is one of the most important acts for Native people and support our right to vote. The 1965 Voting Rights Act outlawed literacy tests, which were particularly harmful to Native communities because many of our elders were not literate in English at that time. Because of the Voting Rights Act, American Indians were provided an easier way to challenge state election laws that denied American Indians the right to vote. A couple of particularly helpful things in the Voting Rights Act was Section 2. Section 2 makes it unlawful for states to adopt voting laws that discriminate against specific minority groups, and that comes in 2 forms: vote denial and vote dilution. Part B of Section 4 of the Voting Rights Act creates a formula that includes all states and jurisdictions that use literacy tests or other tests as a way to vote. So in 1975, the Voting Rights Act was amended, and these amendments are particularly important because they require jurisdictions to provide oral assistance and translated election materials into a minority group's language if there was a certain percent of that minority language spoken in that area. Something neat is Section 203 specifically addressed language barriers for American Indians and Alaska Natives. It requires a jurisdiction that includes a tribal reservation where more than 5% of the voting age residents speak a non-English language to provide language assistance. In 1982, the Voting Rights Act was amended again. In 1982, Congress adopted these additional amendments to address minority vote dilution with certain areas. Vote dilution occurs through a variety of practices and in the weakening of a group's votes, even though the right to cast a ballot is not denied. So these are laws that make it harder to vote, but don't necessarily prevent you from voting. So the dilution of the American Indian vote occurs either through at-large voting, where a majority of voters choose all officials, or reapportionment plans, which divide up or concentrate the Native or minority voters. We saw this in Windy Boy versus Bighorn County, which is out of Montana, where the district court for Montana in 1986 held Bighorn County's at-large elections were unlawful because the plaintiffs there demonstrated a past and present discrimination against Crow and Northern Cheyenne members. Wandering Medicine is also out of Montana, and there the county courthouses are in white population centers. Almost all of the county headquarters are located off of reservations in Montana. And for some Native American voters, traveling to these locations is either too expensive, or it takes too much time, or is impossible. Though not a deliberate attempt to make sure Native voters didn't vote, it had the effect of doing so. So it didn't say, no, you can't vote, but it made it very hard to access the ballot box. That's why tribal members from Fort Belknap, Northern Cheyenne, and the Crow reservations sued to force Blaine County, Bighorn County, and Rosebud County to establish what are called satellite registration and voting sites on reservations. The ACLU of Montana supported these efforts by filing a brief in support of the tribes. And in June 2014, state and county election officials settled the case with the tribal plaintiffs and agreed to establish satellite voting offices on reservations at least twice a week through election day. These are only, so that requirement is only to those 3 specific tribes. After that lawsuit was settled, the Secretary of State at the time, Linda McCullough, issued a directive that made all of the other counties with a reservation within their borders open satellite offices as well. However, tribes are the ones that need to request the satellite offices by January of the year that there is an election, which maybe eventually will get to a place where tribes don't need to request the satellite offices and that counties will just open satellite offices on reservations. But for now, tribes that did not sue in the Wandering Medicine case must request those satellite offices. And finally, Shelby County versus Holder took a step back, right? So all of these things on your screen show you how the Native vote progressed and has gotten stronger, and we've gained access to the ballot box. But Shelby County versus Holder took us a step back and basically invalidated Section 5 of the Voting Rights Act. The Section 5 of the Voting Rights Act required the federal government to review potential changes in covered jurisdictions before implementation. So basically, the federal government had to review laws to make sure it didn't discriminate against minority voters. But in that case, Section 5 is no more, basically. So it kind of took a step back in protecting the minority vote. Even still, even through all the progress that we've made thus far, the Native vote continues to be diminished to this day. Efforts to disenfranchise the Native vote remain, and the COVID-19 pandemic exacerbates these issues. Some of these efforts to disenfranchise the Native vote include not honoring tribal IDs, lack of resources, ballot collection laws, voting by mail, discrimination, removal of federal protections, and language barriers. The COVID-19 pandemic exacerbates these issues by bringing to light already taxing conditions for some voters that are forced to live in. Voting by mail overlooks the Indian population who reside on rural reservations because a lot of these homes lack physical mailing addresses. As a people defined largely by family structures and culture, social isolation is counter to how a lot of us were raised. Finally, we honor our elders, those who are most at risk of contracting COVID-19. So because ballot collection prohibition laws, so laws that make ballot collection illegal, because those particularly impact the Native population, the ACLU of Montana, the National ACLU Voting Rights Project, and the Native American Rights Fund sued. We sued on behalf of Western Native Voice and Montana Native Vote, which are 2 Native American-led voting rights organizations and 5 tribal governments. As you can see, the Assiniboine and Sioux tribes of Fort Peck, the Blackfeet Nation, the Confederated Salish and Kootenai tribes, the Crow tribe, and the Fort Belknap Indian community all would experience an injury if the ballot collection law remained in place. So we were able to file a complaint in March, shortly before, just a couple months ago. And after we filed our complaint, we asked the judge for what's called a temporary restraining order. That means we asked the judge to stop this law immediately because the primary election is right around the corner. It's next week. And the general election is also very soon. So we asked the judge to please stop this law as soon as you can. So the judge in our case granted our temporary restraining order, which means that we got the law stopped for a short amount of time. We've asked the judge for a stoppage of the law for a longer time, which is called a preliminary injunction. However, an identical case on behalf of the Montana Democrat Party was granted a preliminary injunction, so they got the law stopped for longer than we did. So we were originally supposed to argue in front of the judge tomorrow, but since the Democrats got the law stopped in their case, tomorrow we will just have a status conference with the judge to see if our cases will be combined or dismissed. And please keep an eye out on our social media and on our website for more information on the future of the case. But why I'm honored to bring this case is because it's really an opportunity to show the rest of Montana the special harm that Natives would experience if the law remained in effect. So this is a map from an expert in our case that shows the location of Montana post offices and their location on reservations. So as you can see, there's a lot less post offices located on the reservations than outside of reservations. And if you read this expert report, which I don't recommend, it's very long, but it explains the average distance that a person residing on the reservation has to go to a post office, and the average distance that a person not living on a reservation has to drive. So even this map demonstrates how hard it is for Native people living on reservations to access the post office box, which is another reason that voting by mail is not the answer for everybody. So even though the governor did a lot of the state a favor by making vote by mail mandatory for the primary election, it doesn't work for everybody. So fingers crossed for tomorrow and the future of our case. Keep an eye out on our social media. And now Robin and I will discuss who has access to the ballot and who is able to vote in Montana.
Lillian, can I ask a question?
Please.
So what would you say is a win for the ACLU and the tribes that you're representing?
Thanks. So I think a win is to get the law, which is called, we've been calling it BIPA, and it stands for the Ballot Interference Protection Act. Mm-hmm. A win would be stopping that law forever so that people, organizations like Western Native Voice and Montana Native Vote can go and pick up ballots without fearing being incarcerated or being fined.
Okay. Thank you for that. And thank you for that presentation. It's a really exciting time, and we appreciate you making the time as one of the lead litigants on that case today.
Thank you.
So Lillian and I thought we'd talk a little bit about disenfranchisement for people who are convicted of felonies. And to start that, we put up the statute that shows who can vote in Montana. And under this particular law, which is under Montana Code Annotated Title 13, people who can vote are those who are registered, who are 18 years of age or older. So not everyone on this call, I don't think. Resident of the state of Montana, and a United States citizen. And like Lillian expressed so well, even if someone checks all the boxes due to structural inequalities and the lack of resources and just the way that oppressive systems tend to not favor those communities, it's still challenging for people to vote. And so one way that people can be disenfranchised is if they are convicted of a felony. So there's 3 different types of states, I think, that address the issue of people who've been convicted of a felony and their right to vote. Some states, you're basically banned from voting if you've been convicted. Others, you have to go through a process to restore. Montana is one of the states where if you are incarcerated and you're in prison, you are not granted the right to vote. But when you are released, it is automatically restored. So, Lillian, do you have anything to add on that?
Yeah, I just think this point is so important to remember because I feel like people who are incarcerated with felony convictions just assume that they're not able to vote, at least in my experience. And so it's really empowering to remind everyone that you can vote, even if you have a felony conviction. And it's really exciting to be able to register people who do have a felony conviction because they certainly can and should vote. And I'll just jump to the next point as well. Another misconception is not being able to vote if you don't have a residence. A homeless person can register to vote, and even though it's required to put your physical address down, a homeless person or transient person can just describe the area of where they live or provide the shelter that they are staying at. And I know at least in Missoula, the Poverello allows you to do that.
So like Lillian said, the primary election is on Tuesday. So if you are planning to vote and you're mailing in your ballot, you should do it now, right?
Or you can, or it can be collected.
Yeah. Why don't we talk a little bit about, Lillian, the organizations that are helping with that sort of thing? I guess that's a few slides away, but.
So if you need help with voting, I think you can do a couple things. If you're at, and I know this is kind of silly because you're not necessarily going to be at the polls, but if you're trying to turn in your ballot and someone tells you you can't, or there's an issue, you can write to this information, call us or email us. I will tell you that our person who received these complaints will be gone the entire summer, but we have a special group of attorneys ready to address voting rights issues. So we're compiling a spreadsheet of attorneys all over Montana ready to research and support people who are experiencing any sort of discrimination or illegal actions by people when you're trying to vote. So just keep that in mind if you write to us. As Robin said, the big day is June 2nd. So hopefully you've mailed in your ballot by now. If not, I think you can go in person and drop it off. And you can still vote in the general, but this is the primary election is also very important. And then the two, I'll talk about the two organizations that I know more about or the most about out of these three, and then I'll let Robin talk about the third. But Forward Montana, this link goes to their voter hub, which gives you all of the information you need to know about the upcoming election, including how certain people, certain candidates lean on issues and important dates. Similarly, the Western Native Voice link here also provides resources if you have any questions when you're trying to vote.
The third organization is Montana Women Vote, which is a statewide organization committed to increasing participation in democracy with women in Montana. They have a primary election update page that they update very frequently, and so if you follow the link that's in this presentation, you can check your voter registration status to make sure that you are registered to vote. You can change and update your voter registration. You have the dates when you know you need to vote by, and generally Montana Women Vote will have a resource page up for probably the general election that's similar to what Forward Montana and Western Native Voice are doing, in that they'll talk about candidates and their positions on different issues. But you might see Montana Women Vote and these other organizers at the farmers market trying to get people registered to vote, and that's a lot of the work that they do to make sure that all folks in Montana and in our communities have the ability to express themselves through their voting.
One more thing I want to add is, I can't believe I didn't give the link, but you can track your ballot and make sure it was delivered. So there's a link you can go to, enter in your name and your birthday, and it will show you that your vote was received. And this is very important because just this morning I learned 35,000 ballots were undeliverable in Montana, and some of them were rejected because the signature didn't match the last signature you gave, or you forgot to sign the ballot. So it's very important to make sure your ballot was received.
Thank you for that. Oh, that's a lot of ballots.
That's so many ballots.
Yeah, and who signs it exactly the same every time?
Well, and what if I'm trying to do a new signature? What if I'm just trying it out?
Yeah, what if you're trying something new? You should be able to do that.
What does meaningful access to justice mean to you? I think about this a lot when we're talking about reforming the schools in Montana. And I think things like Indian Ed for All are great because you incorporate culture into the curriculum, right? And that's a win. But I feel like it doesn't go far enough because you're still operating in this non-Indian public school system. And that's what I think of when I think of access to justice. So not directly on point, but That's where my head goes.
To the system in and of itself, not just creating like a place at a table that's already been set, but to have, whether it be a new table or a new gathering or whatever it might be, that's the access to
Right.
justice. Yeah.
Right. Thank you for translating that into real words for me.
You said just fine. I think in my work with survivors, because that's generally what my practice has been for my career, sometimes the system isn't set up to help meet someone's need when they've been harmed. And for me, while the legal system can be very powerful for people, and obviously the results you get have created places where people can achieve equality, where survivors can have their voice heard. I think access to justice needs to be about more than just the result, but about the fact that people can feel that they can participate freely, openly, as themselves, but also the people who are hearing them have a commitment to actually hearing the person and giving them an equal opportunity to participate. And if the system doesn't work, how do we put resources into meeting a survivor where they're at that's outside of that system, which can harm a lot of people? So,
right. Quick tangent.
Yeah.
And then we can move on, but it's like when tribes are given more jurisdiction or more authority over non-Indians in their court system, the only way that tribes are allowed to do that is if they look more like state and federal governments. So it's like a give and take.
Right. And I wonder if that's been, I know you've done some work since the new Violence Against Women Act was passed. You talk about these special domestic violence courts. Do those courts have to check boxes from what the federal government thinks is appropriate?
Yes.
Yeah.
So
again,
just
get away from that experience for survivors in their community.
Right.
Okay. So one purpose of Law Day is to make members of our community aware of legal services that are free or at low cost, that are accessible for you, and resources that can be helpful. So as we wrap up this presentation, we wanted to make sure that folks are aware of the resources in your community, your region, and if anyone is listening from another part of the state, in the state. So I guess we have a true or false question as our next slide, which is, let's see. If you have a legal problem and you can't afford an attorney, will one be appointed to you? True or false? Okay, we have a false. All right, so you are correct. The answer is false. Generally, this is only true in criminal cases, and only in criminal cases where the person is facing jail time. In most cases, and I suppose also if you're in danger of losing custody of your kids from the state of Montana, you're entitled to an attorney. But in most cases, the court does not appoint a lawyer if you can't afford one. And so we know that it can be challenging for folks in Montana of just about every income level to be able to afford an attorney with the expense. And so that is sometimes surprising to people. They think that like in a family law case or a bankruptcy case or a landlord-tenant case, that attorneys should be provided. And I agree, absolutely. Unfortunately, that's not where we're at right now. So we're going to talk a little bit about the services that are available to Montanans for those of you who may qualify. So we listed at the top Montana Legal Services Association. It is a statewide nonprofit legal services association that provides representation or advice and support for a variety of civil legal cases. We've thrown the montanalawhelp.org website up because I think that it's a really helpful resource to look at. That particular website has broken down legal topics from family law to bankruptcy. They even have a COVID-19 section now, talking a little bit about, for example, if you're looking for your stimulus check, if you receive an income from disability, what could be going on with your stimulus check, if you're entitled to it. And so it really is up-to-date legal services. This is for people who think that they can complete their legal issue on their own without representation of an attorney. And it may be when you are thinking about, I have a problem with a landlord, or I am afraid that I am getting into some trouble with my creditors or credit debt, or I'm having a hard time qualifying for disability. Any of those issues, you may just want to go to this website, and it will give you an overview of the law. And then if you feel like your question is way more complicated than what they've got there, then you can apply for legal services from Montana Legal Services Association, or maybe a different program. So that is an important program in Montana. Because I used to work for this organization, there is a civil legal services project for sexual assault survivors around the state. It's run by a nonprofit called the Montana Coalition Against Domestic and Sexual Violence. And under a federal grant, they provide attorney services that can be either contract. They're generally contract attorneys around the state who have been specially trained to work with survivors of sexual violence to provide civil legal services. That could include orders of protection, that could include victims' rights in the context of a prosecution that is against the person who caused harm. That could include some limited, sometimes family law, but generally it's Title IX, educational advocacy, everything from advice around creditor issues, but civil legal services that arise for someone who has experienced sexual violence. Another website that is kept up to date very frequently is the MSU Extension Estate Planning website. And this is a really great resource for those of you who want to write a will, don't feel like you need to go to an attorney to set up a complicated trust or leave a lot of property to someone else. You just want a will that shows your needs and shows who you want to leave your possessions to, who you want your estate to go to. Perhaps if you want to put together a healthcare decision-making document to say, this is how I want healthcare decisions made for me if I'm no longer able to make them. All of those resources are updated and really, really helpful. And that's at the Montana State University Extension website that's included there. I have actually been watching some of their trainings myself on leaving property and drafting wills and drafting healthcare directives on, what I might want to happen if I get sick. And I think the materials are fantastic, and that's all free. If you're looking for an attorney for a different sort of issue, there is the State Bar of Montana has a lawyer information and referral service. So these are attorneys who have signed up to be referred on certain types of cases. So if you're looking for a family law attorney in Bozeman, for example, you can go to that website, and there are attorneys who say they want referrals to the State Bar. Oftentimes, those attorneys will also represent you for less of a cost than they usually would, which is called a modest means program.
And then I just like to include these clinics. While they may not actually represent you in court, they can provide really important research and answers to specific questions that are very valuable. And these are both located at the law school in Missoula, Montana, is the Indian Law Clinic and the Veterans Advocacy Clinic. I've experienced with both, and they both do a great job of providing research and like in the form of a memo or a letter for a specific question. And I had one complainant that I referred to these clinics that was a Native American veteran. So they got to work together to help that gentleman out.
Cool. And then the rest of this slide just includes some regional organizations that provide family law services at reduced or free cost through, again, a federal grant. So if you have a case located in Lake County or in the Confederated Salish and Kootenai tribe in that jurisdiction, you can apply for legal services at Safe Harbor. Again, that's for those who are survivors of domestic violence, sexual assault, and stalking. I've included the phone number there. And then if you are in Sanders County, there is also a domestic violence program that provides family law services. So once again, those are regional and a little more limited to a certain part of the state, but nonetheless helpful for folks who are in rural areas. And if you need any additional referrals, if you're from another part of the state, we can certainly talk to you about that. It looks like we got a chat, and it's talking about the self-help programs. Thank you for that suggestion. Maybe what we'll do is put together the self-help link and add it to the recording for this presentation so that folks can see where self-help stations are. So those are, again, programs in our different county courthouses and district courthouses that can help walk you through paperwork so that you can file paperwork on your own behalf. And if the issue ends up being pretty complicated, those folks who work in those self-help stations are generally trained to be able to assess that and can help you get referred to an attorney.
Yeah, that's actually a really awesome recommendation. Thanks. I forgot. The forms at the Montana Supreme Court come with a packet that explains how to fill it out, right? So like, I don't specialize in dissolution, but if one of my relatives needs a divorce, I can go to this website and I can give her the packet that says how to fill out a dissolution, and it walks her through the whole entire thing. So that's actually a great recommendation, and I'm sorry we didn't include that.
Thank you.
So I guess in closing, I would just like to thank Robin for co-presenting with me, and Sarah for putting this together this evening, and all of you for joining us. This is such an important issue, and again, I'm really grateful that the organization that I am part of is working hard to make sure Native people in Montana have access to the right to vote. And please keep an eye out on our social media and our website on the outcome of our voting rights case. And I hope that all of you vote in the primary and register all your family and friends before the general, and make sure to vote. Robin?
Thanks, Lillian. Thank you to Lillian for co-presenting. I learned so much just from this presentation and from putting it together with you, and I appreciate you sharing your knowledge and your passion for this work. So excited that you're a part of the legal profession. And thanks to Sarah for hosting us. We would love to come back and follow up if you ever need that. And if anyone has any questions, you can reach out to Lillian and myself, and stay involved. Thank you.
Thank you guys all so much for all of this. It was a great presentation. We'll have it available through the library's website shortly. Have a good night, everyone.
Enjoy your weekends.
Thank you.
Bye.